Probate is a process to have a will declared valid in court and to get somebody appointed to act as personal representative of the estate so that last expenses can be paid and assets ultimately distributed to the beneficiaries of the will. Probate involves court proceeding. It's technically litigation, but frequently uncontested litigation. In Utah, probate is necessary for estate administration in instances where the estate has real estate or has bank accounts and non-real property assets in excess of $100,000 or more than 4 titled vehicles. All of those items would trigger the need for probate in Utah. It takes easily 6 months to a year in Utah to complete a probate case and is the only way to transfer title to certain assets that are just in the decedent's name. We are able to get some probates through quicker if we have beneficiaries that are involved and responsive and willing to waive notice requirements. Then we can shorten the time frame to as little as 90 days. The things that extend the probate and make it longer case are contention among the beneficiaries. If we have a personal representative that maybe shouldn't have been named personal representative, things that are out of our control that way. Asset volume also affects the timing. If we have difficult assets like limited partnership interests to deal with, then those can also stretch out the time frame to get a probate completed. The primary costs in probate, assuming that it's not a taxable estate, are some court filing fees as well as attorney fees in order to prepare the documents and get someone appointed personal representative and assist with administering the estate. If the estate exceeds $14 million, we have some estate tax exposure as well that could take more time. It'll also be more expensive to pay federal estate taxes that may be due on amounts over $14 million. Probate can be avoided, and there are a lot of probate avoidance techniques. A good way to look at those is tools in a toolbox. A beneficiary designation avoids probate, like on a retirement account or on life insurance policy. But it's not always the best answer because it doesn't handle contingencies well. Like if you name a beneficiary and then that beneficiary is deceased when you die, then seldomly will the beneficiary designation send the money where you want it to go. But those are examples of non-probate transfers. Another common one on a deed is a joint tenancy deed. Will automatically go to the surviving joint tenant. Utah also has a transfer on death deed. But again, all of them are tools and they can be used to avoid probate, but usually they're not the best tool. Sometimes they are, but usually they are not the best. The best tool for avoiding probate is a revocable trust, where you can lay out your plan for distribution and handle contingencies in case one of your beneficiaries passes away unexpectedly before you do. The revocable trust document is a great place to fill in the contingencies and to be able to designate who receives your property, and you can also control the timing of when they receive it to try and help them make better financial decisions. If you have questions about what probate is and why it matters, please contact us at ProvenLaw.